the loss of water. I mean, the solution, if a siphon were to go down on the eastern side, the solution may be to have a well that is closer to the break, for example, assuming there was one in existence, and just putting water into the ditch so everybody is supplied the same way. So the number of contingencies to be sorted out are multiple, and I don't now have an answer for how all those would be met. I mean, one possibility, frankly, would be figuring out some way to divert Lake Wilson water into the ditch as an immediate remedy. I don't know what the physical requirements of that would be, but that may be a solution, faster than you can drill a well. But it may also, if done in the right location, just drop water in the ditch and therefore everybody can continue to be supplied. I don't know how fast you can lay PVC pipe. I mean, that's the kind of thing you might have to consider.
Lake Wilson is over the mountain.
True, but you could pump it up a little bit and have it go down as opposed to pumping up a lot.
A lot of work, a lot
True.
of time.
One more question, Mr. Chair. In previous rulings that the Supreme Court, the state of Hawaii made, I believe with the remand on Waihole for one, was the issue of whether backup for irrigation a reasonable and beneficial use, was that ever brought up?
A backup in the sense of a duplicate allocation?
Yeah.
It's never been granted. It would be inconsistent with the notion of an actual reasonable beneficial use. So the concept is a contradiction in terms. There are cases where people in the past have had multiple sources, and that's fine. Maybe schools, for example, has historically had uses, and they have unused wells, but that's not granting a new right for a dual purpose. I mean, the goal of having backup sources, it makes sense in terms of practical purposes, that's fine, but the notion of granting two different rights when others are in competition for that is a different proposition.
Bill?
In the Monsanto's reply, under Special Condition 8, that certainly takes care of the perpetuity that you spoke of in the first, at the first time. I mean, they say you get to a certain level, 95%, we're out of here and we got no quarrel. So I think that pretty well eliminates the first argument.
No, as a matter of law, it does not.
Well,
That's not correct.
I'm just saying from a practical standpoint.
But not from a legal
I'm not a
standpoint.
lawyer.
From a legal standpoint, it does not.
Well, I obviously, the law firm thinks otherwise.
Law firms argue that case. I'm advising you can't do it.
I'm talking from a practical
I
standpoint,
understand,
sir.
I understand the practical.
And it's impractical?
No, I understand your point from a
Okay,
practical
all
point.
right, so hear me out. That's, the other thing, the other part that I have approved that the following terms and conditions are met. Item B, I mean, that's.
Item B, I'm sorry.
That's not very practical. I mean, that's for the state to determine.
I'm sorry, item B where?
But
To be.
on page 17.
Page top of 17?
Okay, 2B.
Right?
That's for the state to determine, not for the user, I would think. I just, again, as a practical point of view.
The obligation would be on the applicant to find out and provide that information. It may be good, it may not be good, but they've got to go and ask ADC, for example.
If the water's not coming, I mean, it's not theirs to determine, it's the state to determine.
It's not a matter of determining, it's a matter of going and getting the information, providing it to the commission. They'll go to ADC and say, tell us how much time it takes. They'll convey that information to the commission. They're not making the decision about how much time, but
I would be, if I were a user, I would be very reluctant to be, to be Paul parroting what the state said. I think the state needs to talk to us and tell us, not the user. I mean, come on, you're going to a third party and that it.
that is the predicate by which an application will be processed. Whether that's accurate information or not, or whether we rely upon it or not, it's a different question. But in order to have a claim to do something, you have to make an estimate, and with a footnote saying, this is ADC's estimate, we don't agree with it. That's fine. But it's like a logical proof issue. You've got to have that information in order to make an argument that we need the water for 3 years or 5 years or 2 years. It's got to be some factual basis for that statement.
Yes,
Now, you-
and again, I think that's the state's position to tell us, not the user, because again, it's the state that's gonna make the decision. They know what the break is.
I understand
They
that.
know how long it's gonna take, and for somebody standing on the sidelines saying, well, that's what they said, well, I mean, that's not worth the powder to blow to kingdom come.
But they've got to make the argument that because the EDC tells us it won't be available for 3 years, then we have to do
Okay, fine.
it. We'll still check it.
That's, I think it's a ridiculous requirement. It holds no water, but that's a personal opinion, so you hear me.
Okay.
Thank you, Bill. Any questions from this? Ted?
Bill, by definition, backup in this context of double counting, doesn't it mean that waters will not be used simultaneously? So how do you get double counting?
No, it's not that at all. There was those 2 rights. Those rights are standalone. They're not conditional. When you issue a water use permit, it's an indefinite grant of a right, okay? It's not contingent upon something else. So you can't do that. That's the problem. It's not like, and the other issue is, we can get into the logic of granting that same permit to all other people in similar situations. That's what you've got to stand back and say is, this particular applicant aside, if this is now the law, then everyone else in a similar situation has the similar right, okay? If you do that, you've basically allocated out the water for contingent uses, which would prohibit somebody else. Let's say that's all done, that's 100% out. That would in effect prohibit us, the Water Commission, from granting a permit to the next person in line that wants an actual use, because you will have in effect used up your allocation. You can't have a double counting. It doesn't work. It would lead to a situation where, let's say Dole comes in and says, we need 10 million gallons for some use in that area, but all the water has been contingently allocated out. You can't have both. Water use permits are an indefinite grant of a right. And you can't just pull it back willy-nilly because that's not convenient now. Unless there's a non-use, or you change location, amount, or the purpose for which it's used, you can't just withdraw a water use permit. This is not like a lease. That's part of the arrangements when the code was created, that in order to protect agriculture from this kind of activity, they were indefinite leases, indefinite periods. That's not done in other states necessarily. There was a long debate about that. But because of that indefinite right, you can't just pull it back. They're not short-term permits.
Well, again, go back to the word backup. So it means you have a backup source to utilize on an interim basis until the primary source gets restored. So that allocation you're talking about that's going to be disappearing, maybe for a short-term period until the primary source gets restored again.
But you don't, when that occurs, you could grant the water use permit at that time, but not contingently to some event we don't even know when it may happen. Because it forces us to create a reserve within that allocation against that contingency. And what happens if, let's say there's 20 million gallons left to be allocated, and new users come in and you grant permits for all those 20 million gallons. What value then is that conditioned permit in the future? You can't pump it, or somebody else has to give it up. Now, you get into those situations if you face a reduction in the sustainable yields, then we're going to have to review all the permits. But in terms of new grants, it's an unsustainable proposition in terms of going forward. That's the problem. I mean, the real solution is they get their well in, they get the pump installation permit in, they do the pump tests. A crisis occurs. That may be the solution, maybe something else is the solution. Depends on the crisis. And so to presumptively say that's the solution to a problem we don't know yet puts the commission in legally an untenable position. I mean, this will provide the solution they need. They will be able to come back to the commission and say, we had a failure in the Waialae ditch, we need to pump this right now. The chair calls the commission, says this is what's happened. We proceed under the code or under other authority to deal with that problem. So the problem's going to get solved. It's just not going to get solved the way has been proposed in their application. We had to modify their approach to conform with what the legal needs are of the commission. I mean, they're going to have an available to them a mechanism to solve their problem. We're not leaving people out to dry, but we can't do it the way they're proposing it. That's what we're suggesting here.
What other authorities are available?
Well, without getting into the details of how the shortage plan, the emergency powers work, and it's unnecessary at this point, the methods to solve these problems are not limited to the statute. Clearly, the Hawaii Supreme Court has said, and it's true as a matter of law, that the sovereign has police power authority to deal with emergencies. Let's say it was a health problem. Let's say it turns out there's an application of a pesticide in some portion where the Waiahole ditch is served, and that water then became contaminated. It wouldn't be a matter of a siphon. It may be a matter of taking a month to clear it out or whatever you've got to do. That situation has facts that are unique to that situation. We don't know what those are yet. The well here may not be a solution to anything. It may be contaminated. We may have to do something else. So we want to think about the possibilities, but we don't want to have one fixed answer now that may not even address the problems that arise. And frankly, it is inherent in the obligation of the Commission of the Public Trust Doctrine and as the state to protect the public health, safety, and welfare of the people. And that authority supersedes any statutory provision. It cannot be the law that the Commission sits here and says, we're going to take a month to decide how to deal with this. It is like a fiduciary. If you were a guardian for someone, you do not have to sit there with your eyes closed and your hands tied to go through a process when somebody's very well-being depends on it. It is the nature of being a public trustee that that's what you do. When there is a tsunami, you try to follow all the rules, but if you have to go out to save somebody's life, you're going to go do that. That's just the nature of what your obligations are. That's what a guardian does. And those are public trust responsibilities that supersede particular statutory arrangements.
Any further questions? Go ahead.
Yeah. Bill, is the staff's major concern that if we do approve the applicant's application, that it would set a precedence and that you think we would get a rash of
Yes.
people?
Anybody in their right mind would come in very quickly and apply for it.
But then again, wouldn't it be approved on a case-by-case basis?
Not if you had the same situation. There's no legal principled basis. You could then say, we reject this one. Because you'd be getting into an endless series of differentiations that assume someone comes in with the same claim. And many people who depend on surface water systems are in the same situation. In a water management area, I want to drill a well now because, gee, I might lose my surface system. Yeah, everybody's facing that problem. I mean, they're not alone. And from a business point of view, it certainly makes sense you want to have backups. That's not in dispute. The question is whether the Commission should use the water use permitting process as the mechanism to do that when the implications for the whole code, it unravels the code. There are other ways to handle it that don't implicate that problem.
One more time, Lisa, any questions? Okay, thank you. Applicants?
Thank you. Good morning, Commissioners. Yvonne Eves on behalf of Monsanto. With me today are several members from Monsanto. Dan Clegg, the Land and Water Resources Manager for Hawaii. Tony Herman, who manages the Kunia Farm. And Yarrow Flowers, who keeps Dan in line. This is the third time I'm appearing before you today on this matter. And I think, from the staff's presentation, both in August and today, the staff basically concurs with us that, except where we may disagree on the public interest item, that the water use permit that Monsanto applied for, we have met all of the criteria in HRS 174C-49A for new water use permits. The staff in their submittal listed 6 reasons why They didn't think that Monsanto met the criterion for public interest, and we've addressed that in the submittal that's dated November 16th. Listening to the staff's presentation today and the questions that have come out from the commissioners, I want to address what I think are two basic issues that the commission needs to deal with. First of all, Mr. Tam said that when asked about the special condition that Monsanto had proposed, that when the allocations for the Waipahu-Waiava aquifer reach 95%, that the commission has the authority to either reduce the allocation or revoke it, and Monsanto has agreed that we won't ask for a contested case on it. Mr. Tam indicated that you just can't do that because rights are not conditional. All water use permits are conditional. I mean, you have standard conditions and you have to abide by those conditions. And if you don't abide by those conditions, then your permit can be revoked. What Monsanto is proposing is, in addition to the standard conditions, that there be a number of special conditions. And special conditions operate just as standard conditions. If you don't abide by those conditions, your permit can be revoked. So one of the special conditions we propose is that when allocations from the aquifer reaches 95% of the sustainable yield, that the commission can come back, reduce our allocation, revoke our allocation. You folks can decide at that point what you want to do. And Monsanto has agreed that it will not ask for a contested case. All it's going to take is one meeting. In that case, it's not going to be dragged out through years of contested case. So that somebody else who's waiting in line with a permit application, especially, and this is something that Monsanto met with the Honolulu Board of Water Supply before we even filed the application. In our discussions with them, they don't have any immediate plans to ask for additional allocations. If they did, and we thought that the BWS was going to be eating up the rest of the sustainable yield, I mean, believe me, Monsanto is not going to invest this kind of money for that. So, I don't understand what Mr. Tam's point is about how these rights are not conditional based on the conditions that Monsanto is proposing. They definitely are conditional. As we pointed out in our submittal, I think the conditions that we propose, which are 10 in number, they address every single issue that the staff had raised with respect to the public interest. When he talks about double allocations, there are a number of conditions which state that, one, you can never exceed, both the Waiholi ditch permit and this backup well permit, you can never exceed the total Waiholi ditch allocation, which is 2.636. So you can't use double the amount. So when he talks about it's not economic or efficient use because you have double the amount, well, that's not true. Under the special conditions, that's not going to happen. It says that you can only use it where on the locations for the purposes and in the amounts and the water duties that's allowed under the Waiholi ditch permit. Again, we're not talking about double allocations here. The total amount of water that can be used from Waiholi and this backup well will be 2.636. If Waiholi never goes down, then we won't be using this well. If Waiholi goes down for a period of 6 months, you can only use the well for the 6-month period that the Waiholi ditch is down. So we don't see this as a double allocation. The other, one of the special conditions, which is actually a standard condition, it says should an alternate source of water become available, this allocation may be revoked or reduced or revoked. And the thing that's special about this, as opposed to the standard condition, is that Monsanto agrees that it won't ask for a contested case when that happens. So I think we've addressed all of the concerns that were raised by the staff in the public interest section. Again, I don't agree with Mr. Tam that rights are not conditional. I think they definitely are conditional. I invite you to talk to your AG about that. And it's not a duplicate allocation based on the conditions that Monsanto has proposed. The other item that I wanted to talk about, and Mr. Tam had said that, you know, we don't have to go into the interpretation of the emergency provision of the water code today. I think it's absolutely necessary to go into that, because that is the basis for Monsanto objecting to the staff's recommendation. Yeah. If we did believe that, you know, the commission had the power under the emergency statute, if we were convinced that we could turn on the pumps when the ditch went down, we don't want to fight with staff, okay? I mean, it's just that having read the emergency statute and the water code provision, section 48, which requires that any withdrawal of water from a water management area requires a water use permit. I just don't know how you get around that. Staff hasn't addressed how they get around that. The emergency provision, section 62, doesn't say that, you know, all other provisions of the water code notwithstanding. It doesn't say that. When he talked about, I think it was the chair that asked what other authorities there are, and Mr. Tam talked about the duty to protect the public health and safety. If you look at the entire HRS, the way to deal with those emergency situations is for the governor to declare an emergency and issue proclamations. Boards and commissions, unless the statute provides for their authority to suspend laws, the commissions, boards and commissions don't have that authority. Only the governor does. Take an example for conservation district use permits. When there's an emergency that happens, the Board of Land and Natural Resources, there's provisions in the board rules and regs about filing for emergency permits, which call for an expedited process. There's also a process in which you can apply for after the fact permits, because, you know, the emergency happened and you just had to go in there and act, but you have to apply for after the fact permits. But to suspend the conservation district laws, it's the governor that has to do that. The governor has to declare the emergency and suspend the laws. There's nothing in the water code that says that when some kind of emergency happens, that the commission can suspend the laws. You have to go through the governor. The other thing is, the staff is suggesting that go ahead, issue us a pump installation permit, and when the emergency happens, that the commission can immediately meet by phone or whatever and then grant the water use permit. I suggest that it can't, because if you look at the water code, you know, issuance of a water use permit includes requirements about public notice and those sorts of things, and you just can't call an emergency meeting and issue the water use permit that way. So as much as we would like to find a way that staff can be happy, we just don't see, under the parameters of the water code as it exists today, we just don't see any way for the commission to allow for backup sources of water in water management areas except through issuance of a permit. And for that reason, Monsanto is requesting that the commission grant a water use permit for backup from the Waipahu-Waiawa aquifer for 2.636 million gallons per day, subject to the 10 special conditions that Monsanto is proposing. It's on page 7 through 10 of our November 16th submittal. and also subject to the standard conditions to the extent that they don't conflict with the special conditions. Thank you.
Okay, questions for Yvonne? Commissioner? I have a couple.
Sure.
So, why 95%? Why not 75%? Why not 65%?
Well, the Waipahu-Waiava aquifer today is, the sustainable yield is over 104 MGD, 104 MGD. So 95% leaves, more than 10 MGD available. 10 MGD, when you're talking about domestic uses, is a lot of water. I mean, basically, you're talking a huge development project. Those are the kinds of things that, you don't have an application, and you don't hear about it, and 6 months later, they need the water. I mean, those are the kinds of things that are going to be long-term. So, we thought that 95% was, with the 10 MGD cushion, was an adequate amount of water to leave behind.
And then the conditions of no contested case, Monsanto's willing to do that, but does that predicate that Monsanto can't take some other legal action if we decide later on to limit or reduce?
Monsanto clarified that we won't ask for a contested case. We would definitely, and we think that, from the commission's point of view, you should review it rather than it just be an automatic revocation or an automatic reduction, that the commission should be the ones to make that decision. And definitely, Monsanto would like to come before you and state its case, whatever the case may be at the time. But if you're asking whether we'd file a lawsuit against you, no, we're not. We're not looking at those sorts of solutions. We just want an audience before you,
So if you
like
did,
today.
but if you disagreed with the commission's decision, you would have that opportunity, right? Monsanto would have that opportunity.
the opportunity to,
Question the decision of the commission by going to a judiciary process.
I believe not, because I believe
Because
that
of
under the
the-
Administrative Procedures Act, we would have to exhaust our administrative remedies, which means that we would have to ask for a contested case, and since we gave it up,
Okay. And you might not be able to answer this question, but perhaps they would. There's a potable water line on Kunia Road.
correct.
Has any thought been given in this entire process to simply asking the Board of Water Supply for access to that water line in the event that there's a catastrophic failure of the Waihole ditch?
Yeah, and I believe, we met with Board of Water, like I said, before we even filed the application, and did I see, yeah, Barry's here. My recollection was that because you don't know the extent of the emergency, that Board of Water Supply wasn't willing to commit that we could use that as a source.
Because in my mind, I'm trying to think of, so let's say there's a construction project nearby, and they all seem to hook up to the fire hydrants for water for a period of time. So, would you mind coming up, Barry? I hate to put you on the spot, but it just... And you may not know the answer why Board of Water Supply at the... I'm just curious why, you wouldn't, in the event of an emergency, try to work it out with Board of Water Supply to hook up to the nearest fire hydrant during the time of the emergency.
There is a question of service limit. Our reservoir is at I think 645 feet elevation. I'm not sure where Monsanto is, but I think it's about the equal elevation. So I don't know if there would be sufficient pressures to fill the ditch. Because I think it's right next to the Waihole ditch, I believe. And maybe the Monsanto guys can confirm that. Yeah, our reservoir is right next to just below the ditch. Right. So hydraulically, it's difficult to pump it up there. Of course, we have temporary pumps. So depending on the emergency, I think we may have some flexibility or some capability to do that. But normally, the emergency or temporary water meters are off the hydrants. They're 100 feet below elevation-wise, 100 feet below the spillway elevation. So it would be in the vicinity of the Rokunia subdivision, and a temporary meter would be hooked up to the fire hydrant, and then they could utilize that. But it's a 4-inch connection or 2.5-inch connection typically, and that doesn't flow 2.6 million. That's too small. So there's a capacity and there's a pressure issue, I think.
From a practical standpoint, you couldn't stand the jerk for 2 million gallons a day. Probably.
Well, yeah,
In all probability.
and still serve. It's not designed for that amount,
Exactly.
but we do have 3-inch booster pumps that could pump from the reservoir line into the ditch. But I don't know if we have enough to meet the full amount.
Okay. Thank you.
Welcome.
Just exploring all options. And we answered my other question earlier. So, board members, any other questions, or commission members, any other questions before we get a public testimony?
Just a comment, Chairman. I think we're so close and yet so far away, but can Mr. Tam address some of the issues that Yvonne had? Sure. Thank you.
I'll try to do them in the order in which you raised them. The question is whether the public interest information or points were addressed. They were addressed in the sense you talked about them, but they're not answers. Okay, it is not a reasonable beneficial use to grant a permit for zero or for a non-use. That's just not in the cards. With regard to the 95% rule, the problem is the Monsanto is now making public policy for the state with regard to when a sustainable yield number is being used. The problem with the contingent notion of this is there are going to be more applicants coming in as more ag land goes on into production, as the lands north of Waiava go into production. There will be more water use applications that come in. Let's assume 5 years from now nothing's happened. Water use applications pick up as all of central Oahu lands get used. Let's say we're at 100 out of 104 million gallons. Let's say we're at 104. Let's say we're maxed out. Then you have a contingent use here and there's a failure. Who is it that changes in order to accommodate now a water use permit allocation that is beyond the sustainable yield? Let's say it goes on for 5 years. It takes 5 years to fix the siphon. You've now got a situation in which you've legally granted out more water than there is. And you've granted out water to somebody that already has an existing source. So the logic problem is not solved by the conditions. It is not up to Yvonne's characterization of my statement, unfortunately, is maybe I need to be more clear about what conditions mean. Clearly there are conditions and permits. But the problem of granting out a legal right to take water, which is what it is, otherwise it doesn't mean anything. I mean, Monsanto is in no different situation than everybody else relying on surface water. So everybody else has got the same claim. So you could very quickly double the amount of allocations right now. You also have all the lands that have not been in production. They're going to come back and request. The reason we're not pumping that much now is after a while sugar went down. The Waihole water, the amount of production there has actually been fairly small relative to what they thought. But as those lands go into production, there's a reason it's low now, because that's the water that will be used to a large extent to bring back all that agriculture or urban growth. The Board of Water Supply counts on that for its sources for EVA, for example. EVA does not have potable groundwater, and yet all the growth out there is contingent upon the water from central Oahu. So the notion that that somehow is going to be enough, it gives us no planning room in the future. So the special conditions, obviously there are conditions in every permit, but that leaves the Water Commission now at the mercy of Monsanto coming back and saying, okay, we'll consider something. That's not the way the law works. They're a permittee. They aren't driving the public policy decision. With regard to how we deal with a withdrawal of water, clearly we could, if it's required, and I'm not prejudging the issue at this point, say that a water use permit application shall be filed as soon as there is an emergency. We'll consider it on an expedited basis. That may be the way we have to handle it. What if the entire universe of Waihoa ditch water users all come in at the same time? They all face the same problem. There's nothing special about Monsanto in that case. They're one of many. With regard to the Board of Water Supply's description of what their water supply capacity is on Cornea Road, that's not the only source of water. If you can drop water into the Waihoa ditch in various places, it may be more useful to drop it in closer to Wheeler rather than down the road, so you serve all those needs. There is currently, and again, this is not something that's presently available, but is in the works. Schofield Barracks is treating water R1 for irrigation purposes, and they have the capacity to drop some of that water, or Lake Wilson water, or Waiava wastewater treatment facility at Lake Wilson. Some of that water could be dropped in the Waihoa ditch very simply. There's already a physical infrastructure to do that. So that's a contingency that could be handled. Those haven't been explored. So I don't know if I've addressed all those issues. Is there something in particular you want me, if I touched on the ones you want answered?
Well, my main, at this point, because I say we're so close and yet so far away, is that 95% thing. You mentioned that, in essence, Monsanto is driving
Public policy.
policy or whatever, but
It's very convenient for them. I understand why they're doing it. But that doesn't mean they get a right above everybody else and preempt everybody else to stand in position and direct how this is going to be handled. They're going to be, along with many other people, facing a problem if the Waihoa ditch goes down. The commission is going to face not just Monsanto, but everybody. And so to have them be first in line compared to everyone else with a water use permit goes beyond the realm of what's reasonable. And it just isn't allowed under the law. It's not that, we're trying to figure out a way to help them, but this is not the mechanism. It creates legal issues that are untenable. It creates basically a water rush for permits, because they don't have to have the permit. They can come in when they need it. The permit is a way to come back to the commission and say, I have a right, you can't take it away. Sure, maybe they won't go to contest a case, or maybe they'll file a federal lawsuit. They'll claim you've taken my water right away from me. You granted the right, now we're going to take it away from you. The hell with the state courts, we're going to go to federal court. I spent 15 years of my life dealing with that argument. I'm not interested in hearing it again. Okay? Disingenuous.
So thank you for helping us understand the process.
I've got a question. Assuming that we go your route, where they're allowed to do a well,
Home installation.
but not a permit, how long, in your opinion, would it take from the time of a failure to the time you can actually pump?
Assuming the situation is the siphon fail, that particular issue,
Okay.
and there will be other applicants who come in at the same time, the commission will first have to say, if we have a system failure, then we're going to have to look at not just Monsanto, but everybody. Okay? And the solution may be, to satisfy all the needs, we may want to use water resources that are available up by Lake Wilson, up by the Schofield plant, and see if those can provide some of the needs. Assuming that the first thing you need to do is pump the well you got, then on an expedited basis, the commission could meet. We use the processes that are in the code as well as other authority and say, we're going to grant water use permits, and with the condition then, for all the water users, because everybody else is going to be in the same situation, that will be withdrawn for the whole group when the Waihoa ditch is fixed. That'll be the problem that will be faced then. But then you'll know what the problem is, and you will have granted those on the notion that water is no longer available. You will genuinely have a shortage at that point. And so under the code, you can use the shortage and the emergency powers. Those can be done as quickly as the commission can meet. We can get through a process. My guess would be within a week to 2 weeks, if that were the case, if all that agriculture was threatened, we could meet around the clock until we had the things done. I've done that.
Just for the record, 2 weeks would be way too late for, if you're growing a crop, in most cases, 2 weeks would be too long.
I'm not prejudging what
Okay,
the number will be. We could
but I
meet
mean-
around the clock
but I
to
mean,
solve it.
There's got to be a practical time frame to be able to do it, to be able to save whatever you're trying to save.
I think under the current emergency powers, and maybe some disagree with this, but my view is under the current emergency powers, the commission could authorize on an emergency basis pumping almost immediately, subject to a 10-day review. In other words, the outline that we had in the conditions, I think the commission can do.
Is that absolute, or is that just an opinion?
Is it absolute? I don't know what it means, absolute. My view of the law is it allows it.
You say the law is absolute, so.
No, I didn't say that.
Well, you.
The law, I think the law allows
Implied
that.
that.
My view of the law is it does allow it,
It does allow it.
yes.
Well, that gives the user very little comfort. We think we're talking, I don't know. One other comment. I mean, you made the statement to the effect that Monsanto was dictating to us. Well, I don't know. I look at it a little bit differently. You had a bunch, or not you, we had a bunch of conditions or situations where we said it won't work, and so they were trying to come up with a solution so that, I mean, the 95 days or 95% was a suggestion to solve the problem. I don't think it was dictating. I'm defending them right now because I think they've been put upon a little bit here, but that's, again, a personal opinion.
They're asking for a right. It's not their decision, it's not their call to say what that right is by the commission. They're asking for it, they've applied for
They're
it.
making a suggestion to
Right.
solve. You have an objection, and they're coming up with a suggestion as to how to solve that.
They would solve it for them, they would not solve it for the commission.
Okay, all right, fine.
Any other questions?
Well, I'd like to suggest that we move on to public testimony, and then after that, I'd like to ask for an executive session to talk to the AG's office to answer some of the, we have two lawyers who are very, understand this law, and we have obviously, conflict between what's being said, and I'd like a little bit more legal discussion for myself.
I would agree with that comment. We probably have the two smartest lawyers on the water code who are disagreeing.
I-
It makes it very difficult for us to,
Yeah.
Let's hear from the public.
yeah. Okay, so any members of the public wishing to testify on agenda item D2? There are lots of people in the audience. Okay, Ray, why don't you come up? Okay, why don't you just give it to Wayne and I'll pass it out. Thank you.
Good morning, Chair, members of the Commission. My name is Wayne Tanaka. I'm here on behalf of the Office of Hawaiian Affairs. We just had a few comments to offer on agenda item D2. The Office of Hawaiian Affairs shares concerns with the staff recommendation regarding the applicant's request for a reservation of water for a hypothetical future need for a private purpose, which we feel may be inconsistent with the state water code, which requires a consideration of actual needs and to the extent to which they serve reasonable beneficial public purposes. If the applicant is looking for, I guess, a more reliable or resilient water supply than their current situation with their current allocation from the Waiholei ditch system, we believe there may be an acceptable alternative that would be worth exploring, and that would be basically granting a water allocation from the Waialva aquifer and replacing the current allocation, which is from the Waiholei ditch. And the reason we say that is basically we'll be granting them the allocation to tap into what is currently unused water source. Whereas the Waiholei ditch system, there are already recognized existing competing uses with regards to environmental, cultural, and domestic public purposes on the windward side. And yeah, and so just
Any questions for Mr. Tanaka?
The sheer practicality of it, again, is that there are a number of siphons between the Waialva and Waipahu aquifer, and if you're talking about siphons, and it is a siphon, that's not a solution. I mean, just, again, from a practical standpoint, you go up there and you walk the system, you will understand that. So, that's not to say there's not other sources, but as far as your solution, it could still be a problem.
John?
And my understanding of part of what you said is that if they want the assurance that of a groundwater system, that they should apply for the groundwater system but terminate their use of the ditch system, thus freeing it up for other agricultural and also cultural as well as environmental uses. Am I correct in that? Okay.
When did you find out about this application?
We saw the initial application from August, I think, maybe a month ago, and then we've just kind of been, watching the agendas to see when they would be up for reconsideration, and so it just got posted last Friday.
What prevented you from testifying back in August?
I actually just started in September, so I'm not sure what was going on with our office back then.
Regarding your second paragraph in your document, you state that it's an indefinite allocation for a hypothetical uncertain use.
Right.
The submittal seems to be very clear that it's for a backup source for 2.636 million gallons. What do you base these comments on?
Well, I think within the submittal itself, the contingency that it considers isn't clearly defined, and so that's what we mean by hypothetical. There's no, we don't know for sure what's going to happen with Waihola Ditch. It might, be fine for the next 100 years, or it might never be an earthquake next year. That's what we mean by hypothetical or uncertain.
But wouldn't the word backup, give you an idea as to what's being requested here?
It's a backup it's a backup for a contingency that's uncertain.
Okay, any other questions for Wee? Thank you, Wee.
Thank you.
I saw another hand over here.
Hello, Mike. Chair Kaila. Thank you for allowing me to speak today.
Who's with you, Daniel?
This is my daughter, Kula Ilai.
Okay.
I want to share with you guys the catastrophic problem with our water is that it's going to people like Monsanto instead of to the Opelu. You smell that? It's the last of the Opelu on the Waianae coast because there is not a single river that runs 12 months of the year to the ocean. For 7 years, I've been trying to get land to farm kalu. These are the foods that sustain our family. That somehow someone can claim to get millions of gallons of water for non-human consumption food. It infuriates me that you would even consider it for a second. Monsanto never asked the people if we wanted them here at all. Let it be clear that the fish and the taro of Hawaii tell Monsanto to go home. There's not enough water here, move. Because the water is for the fish and for the kalo and for the people. You talk about sustainability. We produce 4 million pounds of kalo a year. It is our staple, it is our starch. We need at least 365 million pounds to feed each and every one of us 1 pound a day. My family of 5 consumes 300 pounds of poi a month. If each family in Hawaii were to consume the same amount, there would be no water from Monsanto, and we would be sustainable. I'm here to convey to you that the real voices that you're not hearing are the ones who can't afford the $2 an hour parking and the gas to drive here. Because right at this moment, they're at work, struggling to buy what? Rice and high fructose corn syrup. We demand that you do the right thing and set the precedent and let these folks know that our water is for food and for people. Thank you.
Any questions for Dan?
Yeah.
Yes, sir.
In the event that the request is aborted, then if there is a problem with the irrigation system, then the priority for that emergency would be that Monsanto would get water to be able to continue, but everyone else farming food would not. Do you feel that that is an equitable vision?
I can't even see how that would be a part of the vision. You know, if 85% of what we currently consume equates to $3.1 billion, farming and feeding ourselves is the single largest growth of industry that we have in front of us, which needs massive amounts of labor. For farming and producing our own food, we will in turn manage our resources much better. They're using this simply as an export, which does not apply to a single one of us. In fact, Hawaii is contributing the single largest contributor to chemical farming in the world through our means of exporting corn seed. Now we need to stand up for this. Our water is not meant for other countries to grow GMO corn. This is serious. Your decision today, in part, will send a clear message that they're not welcome here and that our water is for food. Thank you.
Okay, and one more question. Are you farming kalalohi?
We
Kalikala?
currently have, we don't have a lease. We have a small plot in Honolulu, which we're restoring some ancient patches. We are in discussion with many entities, but the reality is to farm taro, you have to live on the aina. And they refuse to let you live and farm. Thank you.
Okay.
Mahalo.
Live your dream.
Anyone else wishing to testify on this matter, going from left to right?
Morning, ladies and gentlemen.
Good morning.
Morning, Cousin William.
That was it.
I am Kumaoli, Lancelot Haile Lincoln, Kamehameha 8, direct descendant of Kamehameha 1. And I have the documents right here to prove it. You want to see it? Monsanto has been poisoning our land with poison. You see this? That's what I want you to think of before you make a bad decision to allow these people to dig a well on our land for water. Go green, think green. When those other 48 states decide they ain't got enough food to give to us and send here to us in mass and container, we're gonna need every inch of land to farm food to sustain our children and our grandchildren, including ourselves. Now what are we going to do if we keep allowing these big corporations to come in here and just take control of our aina? What are we going to do for our children and our grandchildren? That is my question to you, all of you, because I know you have children and grandchildren like I do. I'm very worried about these people coming here to just take full control of our aina. This aina belongs to all of us. Every single one of you, me, and those behind me. We're not going to sit around and just let these people come here and take control of our land. We cannot do this. Together we have to fight them and we have to stand up to them and let them know these things that they are doing are really wrong, very bad for us. for our keiki. This is not allowed, and we must let them know this. Please, make the right decision and think about sustainability. Think about green. Kosaka, she growing lettuce in Manoa lettuce, you know? This is very good for us. These come from Dlnr. You know, when I speak to my 102-year-old auntie who just passed away a few days ago, and my uncle who's 85 right now, I take him around the island every once in a while. I ask him what, he says, you know what? When you eat, make sure it comes from the Aina. Do not eat man-made things. Now please, be aware of this. We need to stop these people, and we need to stop them now. We can't allow these kind of things to happen on our land. We have to protect our land for ourselves, our keiki, and our grandchildren. Don't ever forget that, please, when you make a decision here in Hawaii. That's all I'm going to ask you. You know, I respect every one of you, and I respect your job and your decision making. But we have to respect one another and all ideas on the table. We put the ideas on the table and work together to solve a solution and come up with a fix. Please make things right, make things pono, so that we can all survive here in our islands. Mahalo.
Thank you. Any question? No. Mahalo.
Questions?
No, thank you.
Have a blessed day, all of you.
Aloha.
Aloha.
Good morning.
Morning. This is the new gang, huh? All new, how many? 4 or 5 guys, all new? From the Water Commission. I'm here this morning, flew in from Molokai, and I represent really myself and the public. That's my only interest here today. As far as beneficial and how that impacts, the social impacts that this issue that's before you guys, it's huge.
Actually, you need to state, even though I know you and I know, you
Oh, my
need to
name?
state,
Yeah.
state
Oh, I'm
your
sorry.
name for it,
Yeah.
because it's not a camera, so.
My name is Walter Riddy from Molokai. So I guess what the first thing I want to try and get across is how important this issue is, not only for water, but for the whole community out there. The impacts on our communities are huge. This company and the impacts are huge. Every little thing has an impact on all of us. So I felt like I needed to come and at least share some of the impacts that are happening on us. And listening to the reasons why all of this is happening. They're going into new areas as far as the commission is concerned, and you have to decide whether it's justified for them to break new ground. They call it backup because it sounds good, backup. The staff is calling it double dipping, water banking, double counting, all those terms to try and explain what is going on. For us on the outside, like, it's getting very confusing about what's going on. But we all know that water is the issue and everything is limited. I come from Molokai and we know how limited water is. So we fight over water tooth and nail to make sure our future generations are protected. So I don't think this is any different. So whatever the name you call it, these guys want to bank surface water and then they want to use potable water. So it's going to come from 2 different places, one from the ground, one from top, one from the other side of the island, one from this side of the island. So in our eyes, somebody is stretching out their long tentacles to make sure that they're going to be pa'a. On Molokai, our tutu tell us that in order to be a farmer, you have to know how to pull it. Because the only way you can get water is to pray for water. And that's how they had to farm. That's how the homesteaders started. So farming is nothing is guaranteed when you farm. So in this case, they want to guarantee. And in order to guarantee, they want to come to the public source that belongs to all of our future generations. So you got to make the decision whether or not you're going to guarantee these farmers. You know, farmers are actually gamblers. And in this case, there's huge stakes going on. So they want to make sure that they get water. So you gotta decide whether or not you're gonna give them the water. And as far as the public is concerned, these guys are huge. What we see is the foot in the door to you guys' door. And however they come in, maybe call them back up, call them something nice, call them whatever, but get the foot in the door, and then all hell gonna break loose because these guys got more money than we got. And they got more lawyers than we got. They can talk nice, bring nice little ladies that we all respect, and come in the door. So before you let them in the door, you better make sure that it's a good reason, because once they get in the door, and having a backup is not a good reason to change our codes and to jeopardize the future of our codes. These codes were worked on years, and I don't know how he can keep his cool over here. He's the guy that's working the hardest on these codes. If you're not going to believe him, who the hell are you going to believe? So I'm here to suggest that this large foot in the door is very, very dangerous as far as the community is concerned. We're taking jerks out there. The way these guys are farming, the community is taking jerks. We're breeding dust every day. We see Molokai turning into a dust bowl. We see the dust and everything going into our reefs. In the dust are all these chemicals. These are chemical companies. I don't know what kind of farmers these guys are going to be. I can only guess. So as far as the community is concerned, we do not support this kind of water use. And, being fair and equitable, they have other alternatives. They have to exhaust those alternatives before they come and get a water use permit, which gives them the guarantee forever and ever. They can take you to court, even though the lady over here, the nice lady, says, no, they're not going to take you to court. Yeah, I can sell you the moon. Guaranteed they're going to take you to court. So you cannot be gullible with these kind of guys, and you have to be staunch and steadfast when you're protecting our public trust. And the public does not trust this situation one bit. We're suffering out there as communities, and we're worried about our health on this issue. So you need to take that into consideration in your decision making. Thank you.
Questions for Walter?
I got one comment. No, don't worry, you're not the only one confused on the issue. It's confusing to us as well.
So don't take a chance.
Thank you, Walter.
Mahalo for flying.
Wika po e malele, wika po e herana mai. Wau no kawa, wahana ui makamokupuni Molokai hawa. Yes, I'm the son of Taro farmers from Halala Molokai, the same place where Walter really comes from. He nui kanina ya oko apau. I have lots of questions for you. So you give the permit to this powerful organization whose home is based not in Hawaii, and they take you to court, and they take you to court. We know how long it took Waihole to get 16 million gallons released back into the river. And during that time, the big powerful organization fought and fought and fought. When the 16 million gallons was restored, for that period of time that they took water from the OA, they didn't have to pay for it. They just took it. Because the law allows for them to take and call it correct, because the law says it's correct. The law says it's correct. We can remember when women were not allowed to vote and the law said that was right. We can remember when blacks were being murdered and the law said it was right. The law is not always right. The law is not always right. I'm afraid that this organization is power-based. It's not in Hawaii. It's not in Hawaii. And I don't believe in giving that kind of right, innate cultural right, to someone else. I'd rather have the state manage the water, all the water system. At what point in time when water dries out and we need water from there, how much will that water cost you and I? Will they charge us for it? Be sure they're going to charge us for it. Was it? Can Kawa'au go without water for 5 days? Possibly. Can Kawa'au go without gas for 1 month? Yes, I can go without gas, but I cannot go, as I said. So the question about backup always comes to backup. Let me tell you a story about Halava Molokai. My father's a farmer in Halawa. And the valley was owned by, at one point in time, it was owned by a number of people. But when Murphy came on, he wanted to take water from Mo'ula waterfall. He took the water from the area at Pu'uoku and dried everything else below. There was not enough water. So they wanted to take water from Halawa. My father and all the farmers in Halawa Valley always wanted to grow more taro, but didn't have enough water. They didn't have enough water. So they adjusted to the situation. They adjusted because the adjustment was a moral right. It looked at the moral well-being of the people in the valley. So my father, at one point in time, harvested 400 bags of taro a month. Top in the entire state of Hawaii. King of taro, 400 bags. No one can ever tell that. Can you imagine the taro farmers on Kauai, if water began to go there, and they start asking for backup? They're not asking for backup for water. They're managing water as a farmer does, as a farmer. Because the farmer's belief is that we all benefit when we take care of the land. Water is not the state's responsibility, it's all of our responsibility. Everyone's responsibility. We cannot look at water for one person to benefit. It cannot happen, it cannot ever happen. How many of you gentlemen know what the word kanawai means and where it comes from? Do you know what kanawai is? I'm not picking on you. I'm just asking you the question. It's an intellectual question as well as a cultural question. It's a spiritual question as well. What does the word kanawai mean? Can I get an answer if you don't know it?
Yeah, division of water, that's our law.
Division of water. It's at this level. You're on the mark. But kanawai. Let me tell you the story. It was about a man who wanted control of water. Something like Monsanto. They're asking for control, but they have a nice word called backup. Everybody should be on backup. Everybody adjusts to backup. Everybody adjusts to backup. Farmers always think about backing up, but they don't ask for themselves. Because farmers believe that they make the adjustment. If there's less water, you plant. So the word kanawai, there was a gentleman who wanted water. He had control of the water. Control of the water. I, the other farmer below, saw that the man who had control of the head of the water was not allowing for life in the community, in the ahapua, in the moku, to survive at its highest level. He had control. Took it before gentlemen like you folks, the commission. But back in there it was called the Dlnr-Monsanto. And both sides presented their story. One said, no, it belongs to me and I want all of it. Kind of like where this is going, but the words are nice, called backup. It's really about control. Yeah? It's really about control. And so after hearing the story, the word comes, Mako'olelo Hawaii, kanawai kelawai. And the ali'i said, the water belongs to you. And all those back of you who want to farm. Not to you who's trying to control the water for yourself. Thus, the word kanawai has nothing to do with water. It had to do with relationship. It had to do with life, the sustainability of life. So the one individual who wanted to control was not given that right to manage the water. It was given to the individual whose purview was greater than I. That's your task, to look after us all. That's your task. I vote no on allowing banking. I vote no. And I'm not alone. And I'm not alone. In Makaha, we want to get water from the border water supply because they have wells. Not much. Enough for 4 taro farmers to begin. We have a hard time getting water from that. Yeah, we have a hard time. We should be allowed to ask for it. We're not asking for a lot of water. We're not asking for all of the water. We're asking for 4 farmers to begin. If we allow 4 farmers to begin, why is it that we should not be looking at taro as baby food for the world? Why shouldn't we produce that? But we should not produce taro, GMO taro. Absolutely not. It's culturally an insult to us. But we can grow enough with our own technology, with our own ike from a cultural perspective. And we all have cultural experience. That's where we need to go to when we make our decision. We need to really reach back. What would your great-grandfather say about water? What would your great-grandfather, what would your great-grandmother say about water? There was a conference in California about the struggle for water. All the governors of the states went there. They all went their list of what they wanted. And when they left, they left with what they needed, not with what they wanted. Mahalo.
Thank you. Anyone else wishing to testify on this matter?
Hi, my name is James Macy, just a concerned citizen, not representing anybody. Monsanto sprays a lot of pesticides and herbicides up there in Cunilla. They run, 4 crops a year, 3-4 crops a year. And I'm concerned as a citizen that, putting a well in the midst of all that poison is like putting an IV of poison into our water table. Now, I've asked the water supply, Board of Water Supply, do they check for pesticides and herbicides? And they said, yeah, they do check for some pesticides, but I get crickets when I ask them about herbicides. And I'm just as concerned about herbicides as I am about pesticides. My question to you guys, or to you, Mr. Chairman, I guess, has Monsanto provided you a list of poisons that they spray out there in Cunilla? And do you guys check for those in our water supply, our potable water supply that we drink, and also our water table? I personally would like that test done before you guys approve this request.
Short answer is no. The Water Commission doesn't test. The Board of Water Supply is responsible for testing those kinds of things. That's the answer.
Okay. I'd like to test it before we approve this.
I had actually made a similar comment and request at the first meeting where this issue was brought up, that since the original wells that were serving this property under a Dole company are polluted with cchemicals that were added at the time of Dole planting and cannot be used. In fact, there's an EPA consent decree to clean up that plume, and that there's likelihood of chemical additions to the soil. I had put in a request that we condition any action on this in a way that the applicant would have to provide us a list of all chemicals, all pesticides, herbicides, fungicides, anything else that was added in the wellhead protection area or on the lands. I still feel that there is merit to that, but I've been told that that's not really our issue as a commission, that's wellhead protection areas, and that is under Department of Health. We do have a director of Department of Health on this board. She's not here right now, but I have asked staff to report back to us on what mechanisms we can utilize to ensure that our valuable, precious aquifers, which are our life, do not become polluted, and that we know what's going into the ground in the future. We don't need to make the same mistakes that we made in the past.
Yeah, as a concerned citizen, it seriously concerns me that we're going to put a well out there in the midst of all this poison. I want my water tested before this goes in.
Thank you.
Thank you.
One more time, going from left to right. Anyone wishing to testify?
Thanks.
Aloha. My name is Opono Kealoha. Again, I don't like being here because you guys actually don't belong in control of our sovereign nation. There's no treaty, there's no annexation, but to have a global corporation come in here and basically suck us dry for everything they can get and then dump us, toss us like some piece of Opala. They don't care about our Aina, about my mainland. This is my place. My children and their children's children will be looking at me when they can no longer eat or no longer drink what's from our Aina. We have to think about that. You have children, you have family here. There's a lot of information of the HEVA about Monsanto and what it's done to other nations and countries. India, you gotta go online, you gotta Google it. Roundup is like a form of Agent Orange. Look at what it's done to Vietnam. This is what they're putting into our Aina, into our water, into us, into our soil. The FDA is a revolving door of Monsanto. They have CEOs that go in there, turn their heads, and get out, back into Monsanto. You guys have to do your research, okay? But you have family here. You drink the water here. You gotta care about that. Care about yourself, your families, but especially appreciate the people that were here, that we're standing on, our iwi kapuna. Would they approve of this? Mahalo.
Thank you, Bob.
Good morning. My name is David Martin. I'm a longtime taro farmer and have followed the Water Commission for many years since its inception. My concerns have always been in the area of the processes that have accompanied the Water Code and the whole subject of planning. To me, this matter really should not be treated as a permitting matter. It should be treated as a planning matter. This is totally dealing with subjects that are already set up to be managed under the Water Code, water shortages. And there are many questions. I would very much like to applaud the staff for the work that they've done on this so far. The observation, recommendation, and the efforts that they're trying to walk a very fine line here. Denying a water use permit, but going forward with a well. I have some concerns about that, mostly related to the issues of the use of the land. It's, toxicity. It's pretty well recognized globally that we're having major problems, and on this same piece of land, we've dealt with the issue of, toxicity in the water. I don't really believe, although the staff says that they have enough information to move forward on this at this time, I disagree. I don't see why there should be no consideration of the reasonable and beneficial use of the water coming out of Waihole. You have a new user, you have new crops. I think that should be on the table at this time. They have opened the door, and it should be addressed. We have studies that are showing major declines in stream flow that are still being studied. What water is actually available coming out of Waihole right now? Do you know? What have the flows been? What have the flows been since the award? Have there been reductions? There's a study that says that there's probably a 20% reduction. Whether that shows up in the ditch flow, I don't know. But I don't think you folks know. We have the whole issue of recharge, the availability of water in this aquifer right now. It's under study. We're looking 2 years out before we have an answer. We have the whole subject of reused water, a study going on about that. Is it available or isn't it? These folks have been asked to provide information about that, but they haven't done their work on that according to the submittal. They haven't provided you information. At this point, on page 5, it's indicated that Waihole ditch water is the Commission's preferred source for water in this area. I disagree at this point. I don't think that you have enough information to continue on that assumption, especially considering the effects that have been occurring to stream flows that have been already identified and presented to you. Your public trust obligations have been very well covered by the preceding speakers immediately before me. From the heart, I cannot add to that. I believe all of these applications should be deferred. I believe there should be the completion of the water plan that was supposed to have been done 25 years ago, that has not yet been completed. And again, this is a planning matter. This is a long time, drag the tail issue that has never been addressed. Complete the regional water use and development plan. I started at the very beginning of this code addressing the subjects of Hawaiian interests and water rights and stream flows. And that's been the primary concern. How, in the planning process, is this ever going to be addressed? It's obvious that it's been kicked down the road. The can has gone and gone and gone. It's been kicked down the road. And now you have some people, corporations, not people. This is a corporation coming before you. We had people testifying before you. I would certainly hope that you would regard the testimony of real people above the testimony of the corporate interest. These people are not going to provide food for us. They may provide some jobs and a lot of workers' compensation claims. But it's in your lap. I don't envy you the position. But I highly, highly hope that you will honor the requests of the local folks here and understand their interest in protecting the water into perpetuity. I cannot accept any decision that would allow this corporation to get their foot in the door first before anybody else. This is the privatization of water interests. You must understand that, and you must respond to it accordingly. Mahalo.
Anyone else wishing to testify? Okay, so someone, you want to make that motion?
Yeah, can I make a motion? I move that we go to executive session so we can talk to the AG's office and get some clarification on some more.
Do you have a second? Second to go into executive session. Okay, there is a second. All those in favor say aye. Aye. Any opposed? No? Kanunu? For executive session.
I go into executive session, but I would like staff to be able to join us.
I don't believe that that's possible in executive session.
Then I vote no.
Okay, so one vote no. We have 1, 2, 3, 4, 5. So we go into executive session. We will be back. The Water Commission is back in session. We're going to lose several members of the commission. It is unlikely that we are going to be able to have a decision today. So the plan is to go forward and defer this decision making to the next meeting in December. We'll let everyone know when that meeting is scheduled. And I think that's what we're going to do. Okay, so apologies to you folks, you're gonna come back for a fourth meeting. This is a very, very tough decision for the commission to make. As I said earlier, I mean, the two most knowledgeable people are disagreeing about the water code, and so we have to do our due diligence and make sure that the decision is as well thought out as possible. Okay? So
You are having a meeting in December?
we will be having a meeting in December. Okay?
Mr. Chair, this will be a special meeting and it
No,
will be.
we're just gonna move up the December meeting.
We're just gonna move it, it's gonna be moved up. to try and get
Regular
the
December
vote.
meeting will just be, try to do it earlier than we had scheduled.
Okay, so in other words, it'll be a meeting at
Regular
a new
notice.
date, and the new date will be
No,
published.
Yes.
Yes,
Yeah.
regular scheduled meeting,
We'll follow
as soon as we
such.
can reasonably do it.
So it's not gonna be the third Wednesday, it's gonna be a different, earlier,
Like
hopefully
it's-
earlier date.
Actually, I guess to make this legal, I move that we defer this
Yes.
issue that is before us until the next meeting.
Thank you, Sumner.
Second.
Moved in second, all those in favor say aye. Aye. No one opposes, motion carries. Sorry, folks. Happy Thanksgiving, everybody.
Come on, everybody, scream cool.